It's time for The Verdict. The Verdict is a lively discussion of current events and legal issues pertinent to Oklahomans. The Verdict is hosted by Kent Meyers and Mick Cornett. The Verdict is brought to you in part by Betcher, Martin, Jean, and Jackson, when hurt people need help. Betcher, Martin, Jean, and Jackson in Ponca City. It's time for The Verdict.
And welcome to The Verdict. We're pleased you can join us today. We're having a special edition today, a 1-hour show. So if you were planning to go someplace after the first half hour, please cancel those and stay with us. It's going to be an interesting show. Before we get into that, however, let me take a personal minute to congratulate our co-host here on The Verdict, Mick Cornett, for his victory in the mayor's race in Oklahoma City. Mick's not here today. He's out doing city business, but he will be joining us off and on, more often than not, in the future. Today we're going to be talking about tort reform. Do we need it? Do we want it? And we're going to have an old-fashioned debate between both a proponent of tort reform and an opponent of tort reform. Just a little bit about the rules. This is going to be a timed debate with timed answers and timed responses. There will be an opening statement, then questions to each of our participants, and then near the end of the show, our participants will be entitled to ask each other a question. And then finally, we'll close it up with a good old-fashioned closing argument. And when we get through, we're going to give you some information about how you can vote on how you think this debate came out and whether you're in favor of tort reform or not. But let me start out right now by introducing our two participants today. Across the table from me on my right is the Honorable Glenn Coffey. Glenn is a Republican senator in the Oklahoma State Senate and has been in the Senate since 1998. He is speaking for tort reform today. He's an undergraduate of Northeastern State University and a law graduate of the University of Oklahoma. He practices corporate law with the Phillips McFall firm in Oklahoma City, a large and very prominent law firm. He is active in community and religious organizations. He is married with 4 children. This is your first visit. I hope not your last. Welcome, Glenn.
Thank you very much. I'm glad to be here.
We're glad to have you. To Glenn's right and across the table from me is an old friend of mine, Ed Abel. Ed will be speaking in opposition to the tort reform proposal today. He is the senior partner in Abel, Musser, Sokolowski, Morris, and Curry, another prominent Oklahoma City law firm. He is an undergraduate of University of Oklahoma, and he graduated with his law degree there with distinction in the top 5% of his class. A class, by the way, where he was the president as well. He's a member and past president of the Oklahoma Trial Lawyers Association and a member of the American Trial Lawyers Association. Has been involved in many Oklahoma Bar Association activities and has taught at many continuing legal education seminars. He's the co-author of the Oklahoma Evidence Code and the Oklahoma Pleading Code. Just like Glenn, he is married with 4 children. Ed, welcome to The Verdict. We're glad you're here.
Thank you very much.
Now, fellas, I have gone over with you the rules. I will be giving you some time cues, but let's start out right now with the opening statements, and we'll start with Glenn. You have 2 minutes.
Thank you. Well, it's a pleasure to be here, Kent, and I'm also honored to be here with a distinguished colleague who obviously represents our profession well. And I think when you hear the discussion about tort reform, people ask, what is it? There's a lot. Maybe it's not on people's mind as a key issue of the day. But I think when we talk about this issue or lawsuit reform, that it's really about the issues that go back to some of the founding principles of this country. One is the Constitution and the civil liberties that we maintain and the rights and responsibilities that we hope to protect. I think an equally important concept that our founding fathers wanted to protect was that of free enterprise, that through commerce, consumers and producers of industry, that we wanted to provide a free and fair environment for our country to grow. And I think that we have to balance those issues in a modern society, the rights of the individual and the opportunity to grow and produce product there are conflicts, and we have to have a civil discourse about how to deal with those conflicts. And that's really what this discussion is about. Some people want to say that this is about putting trial lawyers out of business. I certainly am not here today to put a group of people who truly want to help those who have been harmed, who have been dealt a blow, that need to be represented. That's why this was created.
30 seconds.
And we still need a legal system that's fair and accessible to the public. But we also need to deal with excesses that occur in any industry from time to time. And that's what I hope this debate will be about today, but also at the Capitol as we consider legislation on this important issue.
Thank you. Mr. Abel or Ed, your opening statement.
Okay. Well, thank you, Ken, and I appreciate what the Senator has said. You know, if you read the Daily Oklahoman in the editorial page, it sounds like that they have couched this to be doctors versus lawyers, and the lawyers are portrayed as money-hungry, grubbing guys who are all for the tort system, and that's what it's all about. And in fact, that's not what this issue is about. The issue involving tort reform, a tort, that word means a wrong. That means where you have been wronged, somebody has been negligent, they have caused you an injury, and your ability to receive compensation for the injury that you received at somebody else's hands. Our legal system, since this country was formed, allowed people to go to court. That's the civil way of having their injuries addressed, and that they could receive fair and adequate compensation. And that's what we're talking about. The reform that they talk about is to do away with part of that system, to put limits on what you as an individual, as an American citizen, as an Oklahoman citizen, are entitled to have if you are wronged at somebody else's hands. So my position is that we do not want tort reform, that our court system is adequate to allow both business to flourish here in Oklahoma and in the United States, which it does, and also to be able to allow the individual who is seriously injured to be able to go to court, to have citizens just like yourselves sit and listen to the details of the evidence in a particular case and be able to say, here's what justice demands, and to be able to receive justice through our judicial system. Our judicial system is the best anywhere in the world, and so I hope we will maintain it.
Thank you, gentlemen. Let's take a break. You're watching The Verdict, a debate on tort reform. We'll be right back. We're back. We're having a one-hour debate today on tort reform with Glenn Coffey and Ed Abel. Let's get right into the questioning of our participants. Start with Glenn. Glenn, let's talk about the proposed cap on non-economic damages, such as pain and suffering, disfigurement, loss of relationship with family, permanent disability. There's a proposal to limit that to $300,000. Why should any cap be imposed, and is $300,000 the right limit?
Well, I think that's a great question, and it's an important one to answer, because when you hear somebody say that you're limiting damages, your immediate response is why. And it's important to clarify that there's no proposal that's recommending that we limit actual damages. The proposal is only for non-economic damages, the pain and suffering, the element that is very difficult to quantify. Yeah. And certainly there's quite a bit of support from that, from members of the legislature, even former opponents of reform, such as Governor Henry, who now has decided to support it, have recommended it. I have some concerns about the governor's proposal. There's some holes, I think, that really make his cap not much of a cap. But I think it's important because it is difficult to quantify that. There needs to be some limitations on it. In Texas, for example, when they passed the non-economic damage cap, the next year, med-mal insurance rates went down about 12%. we didn't really address that issue in the minor tort reform that was passed during last legislative cycle, and consequently doctors, med-mal, especially in the OBGYN area, increased up to 85%. So there seems to be some correlation there. There was also one study that said that from 2000 to 2001, in states where there were caps,
30 seconds.
In states where there were caps, the insurance rates increased somewhere in the neighborhood of 10 to 12%. If you look at states where there is no cap on non-economic damages, it increased as much as 20, 25%. So there seems to be a correlation with no limit on those damages and a rising cost, especially in the healthcare arena.
Ed, your response, 1 minute.
Okay. Well, if you look at all of the states that have passed tort reform, and you look at the independent studies, the one that Senator Coffey refers to was done by the insurance company. But if you look at all of the states where tort reform has passed, rates have increased more in those states. For the doctors, the insurance premium rates have increased more in those states than they have in the states that don't have tort reform. And one of the reasons that they have increased doesn't have anything to do with lawsuits, but the studies by the General Accounting Office of the United States government shows that it's due to the stock market and the investments that the insurance companies have made, and because of reinvestment on the part of, or reinsurance on the part of the insurance company, where an insurance company
15
buys
seconds.
insurance to cover their losses. And that's the reason that those rates have gone up, and tort reform has not had a substantial effect on reducing doctors' rates.
Thank you. This question goes to Ed Abel. Ed, aren't there cases where juries just get mad, or where the cases filed are frivolous and defendants are punished with huge verdicts that have no basis in fact? And if that's the case, shouldn't there be limits on this? You have 2 minutes.
Okay. Thank you. There are some aberrations. There have been some large verdicts that have been returned in some cases, and those are the ones that are reported in the newspaper and the news media. You don't hear about 99.9% of the cases where that doesn't happen. We shouldn't change our whole system because there might be one or two or a few cases where there are large verdicts. Now, sometimes large verdicts are very justified, but the large verdicts, out of all of the verdicts, are less than 1% of all of the verdicts that are brought back by juries in this country. So it's not a major problem. You find people talk about tort reform and they want to do away with frivolous lawsuits, for example, but the proposals don't do that. What they really are designed to do is to cap any kind of a large verdict. The system currently allows a jury of 12 people, good Oklahoma people, to decide, after listening to the facts, what is fair as far as the amount of damages that should be awarded in a particular case. And that's the best system, not some arbitrary cap that applies across the board to every case, regardless of what the facts are.
Thank you. Glenn, 1 minute response.
Sure. Your question pointed to the juries, and I think we need to be careful. I don't really think that it's an issue of whether juries are out of control. I really think it's incumbent upon members of our profession, the members of the bar, when we analyze a case before we decide to bring it forth, we need to determine the merits of it. And, you know, with the purpose of bringing something to trial, or at least filing the lawsuit, and making an effort to plead punitive damages is an effort to bring about a settlement. Oftentimes, it's not respective of whether of the merits of the case itself. And that's why in the Republican proposal on punitive damages, we've said if punitive damages are intended to be punitive, maybe they shouldn't go towards attorney fees or even to the plaintiff, but to help with healthcare costs or something, because they're intended to punish, not for the plaintiff to benefit from them.
Thank you. Now, Glenn, we'll come back with a question to you for a 2-minute answer. It's being proposed that Oklahoma adopt a loser pays provision in relation to the payment of attorney's fees. In other words, the loser in the lawsuit has to pay the attorney's fees of the winner. Is this fair? Should it be done? What do you think?
I think this is one of the most reasonable provisions of the lawsuit reform that's being proposed. loser pays, or some people like to refer to it as the English rule, as if it's unusual. We're the exception in this. All the other countries in their legal systems have a loser pay form of compensation in their legal system. We're the exception. I think it makes sense. I think that it makes people analyze the merits of a case before they file it. And it goes both ways, because if there's not merits to a case and somebody wants to combat it and they really have harmed somebody, they're at risk as well. Both sides share risk in that, and I think it's a provision that is worth looking at.
Ed, 1 minute response.
First of all, I want to say, in response to what Senator Coffey said a moment ago about punitive damages, and maybe the punitive damages should go to pay for something that would benefit the state, that's not a part of the current proposal in front of the state legislature. Now, as far as loser pay is concerned, unfortunately, Senator Coffey works for a large law firm that represents insurance companies, but he doesn't try personal injury cases. And he doesn't understand, I think, in all fairness, how this system works. Every case you take to trial is not a clear winner or a clear loser. There have been some very legitimate cases that you go to court on, and they're very expensive to prosecute, and you may lose that. Then you're going to punish a person for bringing a very legitimate claim that they couldn't win for one reason or another.
15 seconds.
And therefore you're going to punish them, and what that's going to do is it's going to close the courthouse doors. People can't afford to go to trial against some large drug company, against General Motors, against Ford, for the fear that they're going to lose, and then they're going to have to pay all of the expenses for that other side, even though they had a very legitimate case.
Thanks, gentlemen. We're going to take another commercial break for a couple of minutes. We'll be right back. You're watching The Verdict and a debate on tort reform. We're back, and you're watching a special 1-hour edition of The Verdict debating tort reform with Ed Abel and Glenn Coffey. Let's go back to our questioning. This question is directed to Mr. Abel. Ed, it's widely publicized, and you mentioned it earlier, that doctors are leaving the state or the practice of medicine because of rising malpractice insurance rates. Isn't it also true that the medical malpractice insurance companies have lost a great deal of money in the stock market decline? Are they trying to make it up in premium increases? What do you think? 2 minutes.
Well, Kent, it's a scare tactic used by the insurance companies to say that doctors are leaving the state, because that's simply not true. We have a graphic here and I'll be happy to send, if anybody will call me after this program's over, I'll be happy to send you a copy of any of this material I refer to. But the General Accounting Office of the United States government did a study, and it showed that the number of doctors was increasing across the United States in almost every community at 23% faster than the general population. Now, it is true that some doctors are moving from the country going to the city because they can make more money there. But the big problem is not that doctors are quitting the practice or that they're leaving the state. That's just simply not true. It's not happening. But it's like if you say it often enough, then maybe somebody will believe it. Insurance rates for doctors are up, but nobody's looking at why they're up. Now, that same General Accounting Office of the U.S. government published a study showing that those rates are up because of losses in the stock market. And in fact, Mr. Robert Hunter, who was the insurance commissioner when our current president was governor of the state of Texas, and he was also the advisor on insurance economics to both President Carter and Ford, came out with a publication and said that the insurance rates follow the stock market. When we've had a low stock market, a low economy, such as after 9/11, insurance rates go up. And that's historically true.
30 seconds.
One of the other factors why doctors pay high insurance rates is each doctor pays the same rate. Even though 5% of the doctors are responsible for 56% of the medical malpractice lawsuits are filed, those doctors don't pay any more money than the doctor who has never had a claim against him. And that needs to be changed. And that was done in California, and it brought the rates down.
Thank you. 1 minute response, Glenn?
Sure. With all due respect, I have to differ with my friend here. You know, we try to bring insurance companies into this debate because nobody likes to have to deal with that industry when you've got a problem. And so we try and bring somebody in to vilify. But even if that national study, which were true, we have the facts here in Oklahoma, and it is different. PLICO is the insurer of choice for doctors in the state. About 85% of the doctors use one insurance company. In the last 5 years, their claims have doubled from what they once were, as far as what they're paying out in settlements. At the same time, their portfolio has averaged a pretty decent return, but yet their costs are going up.
15 seconds.
So it's a pretty clear case, at least in Oklahoma, that the costs that are, and it's a claims-based insurance provider, so the costs are laid out and they're clear. It's the settlement of frivolous claims that are driving costs up in Oklahoma.
Thank you. Now let me direct a question to you, if I may. There's a provision dealing with joint and several liability, and I'll just say in summary that is a situation where each defendant would be responsible for all of the damages awarded. And joint and several liability has been a part of our law in this state for a long time. In many kinds of cases, there's a provision to change it. Why should it be changed?
Well, I think outside of the legal profession, there's a large cry for people ought to be responsible for their part of a fault. But with joint and several liability, we have a situation where we go after the deep pockets. You may have 1% liability. You may have minimal impact on what happens. But as a result, if there's somebody with a lot of money involved, that's who we go to because that makes the economics work of this case. You know, one proposal that, again, a Republican proposal, and Ed, there are many out there, and until we get to the end of session, we really don't know what will be included in the bill, but is to make people financially responsible, consistent with the amount of responsibility they bear in the accident or whatever the problem is.
Ed, your response for 1 minute?
Well, Senator Coffey is right. There's many proposals that'll be out there, and we don't know which one will come up yet. But the whole idea behind joint and several liability is that if you've got an injured person who is not at fault at all, and there are two or more other people who are responsible for his injury, they are at fault to some percentage, then as by comparison between the innocent injured party who is not at fault at all and any one or all of those people who are injured, who caused the injury, that is, and without their act the injury would not have occurred, and that's an important statement. Without their act this injury would not have occurred, then as between them and the injured party, they should be responsible for a portion or all. Now, if one of those defendants pays all of the damages, then he can turn to the other defendants and get his money back. So ultimately, he should end up paying about his proportionate share of that verdict, assuming that there's enough insurance there.
15 seconds.
The Senate could solve this whole problem by increasing the minimum amount of liability insurance that we're required to carry in Oklahoma. Right now, that is only $10,000 per person. If they would up that rate, it would do away, or if they would up the minimum amount we're required to carry to like $50,000, it would do away with most of the problems that Senator Coffey is talking about.
Thank you. Now a question to you, Mr. Abel. Last question before we take another break. It's being proposed that punitive damages be harder to obtain by requiring a unanimous jury verdict. If punitive damages are excess dollars awarded over and above the actual damage sustained, shouldn't it be harder to obtain? And isn't this just being more fair to all concerned?
Kent, punitive damages have a very definite purpose in our system. You have two types of damages. You have compensatory damages that are designed to compensate the injured person. You have punitive damages that are designed to punish the defendant, and it's granted in less than 1% of all of the cases, and it's only granted against defendants who commit gross, wanton, willful, or intentional conduct. Now, right now we have juries of 12, and it takes 9 people out of 12 to return a verdict. That is so that you have some flexibility. You have to have a big majority, but you can't let one person hold up what, say, 11 other people want to give. Punitive damages are awarded in cases such as the Ford Pinto case, where Ford designed their Pinto and they put their gas tank in there, so at a place where if you got rear-ended, it would cause a fire and many people burned to death. And Ford made a calculated economic decision that it was cheaper to pay the damages than it was to change the design. So they got hit by a big punitive damage award. And those awards have to be big against a company like Ford. $100,000 isn't going to mean anything to Ford. Or cases where little girls' nightgowns were made out of very flammable substances, and a spark from the fireplace would cause them to become a living torch. That got changed only because of punitive damage awards against those companies. So punitive damages plays a very big part in our system.
30 seconds.
And Senator Coffey said something a while ago that is of great interest to me. Maybe all the punitive damages shouldn't go to the plaintiff because he's going to get compensatory damages. But doggone it, that's not a part of the proposal out here. The proposal just wants to put a limit on punitive damages, and we already have a limit. In 1995, the legislature passed limits on punitive damages and made them harder to get. We don't need another change today.
Senator Coffey, your response, 1 minute.
Well, I spoke to this, as Ed said a moment ago, on these damages, but let me just say that, you know, in my opening comments I talked about we have to balance the civil liberties versus the free enterprise concepts that are important in this country. There perhaps are and perhaps should be circumstances when we need to punish a wrong, but in the one example that was brought up about the flammable pajamas for children, you know, did that really change anything? I mean, if you go into any children's store to buy pajamas today, you have children's underwear over there that's not flame retardant that people are buying and putting their kids in.
15 seconds.
But all this money was put into a trial to supposedly right or wrong, but the free market finds ways around those things sometimes. And we need to find ways to not just encourage the medical industry to practice defensive medicine.
I'm sorry to interrupt.
That's all right.
Time has expired, and so has the time for this segment. You're watching The Verdict. It's a special edition on tort reform. We'll see you in a minute. We're back with our special hour-long segment of The Verdict this Sunday on tort reform and a debate between Ed Abel and Senator Glenn Coffey. We want to continue on with the questioning, and I'll direct this question to Senator Coffey. Glenn, why should we require pre-suit certification of claims when the claim is of medical malpractice? This isn't done in any other area of the law. And if the claim is frivolous, why sanctions against the plaintiff and the plaintiff's lawyer are available? Aren't we creating too many hurdles for the plaintiff? 2 minutes.
I don't think so, Kent. I think one of the most important public policy issues that we face as a society today is that of rising healthcare costs. And we're all impacted. And we need to analyze every aspect that's driving those costs. And certainly the medical malpractice issue is a component of that cost. I think it's reasonable to require a pre-certification of the claim. Only about 6% of med mal cases are successful. So given such a small return on likelihood of success, it makes sense to me that a pre-certification of determining something that is going to have to be proven anyway to be successful, it doesn't preclude you from bringing them. It simply streamlines those cases that don't show merit and helps hold down the cost, because the average med mal case, just in one that's settled, on average costs about $40,000 in legal fees. If it goes to trial, it goes well in excess of 6 figures. And so it makes sense to me that on the ones that have merit, that need to be litigated, that we reserve time in the process for them and streamline the cases that shouldn't have been filed anyway.
Ed, your response for a minute?
Well, I think I have a graphic on this also. This is already the law. And any lawyer who handles medical malpractice cases is not going to spend the money to prosecute that case on an average of about $40,000 before he knows he has a case. And so this is already the law. We don't need any new law to take this kind of a thing. Now, Senator Coffey has mentioned frivolous lawsuits. The court already, and we have another illustration here with some citations of some statutes I want to show you, where the court already has authority to fine lawyers and fine parties for bringing frivolous lawsuits. If I bring a frivolous lawsuit, and Senator Coffey's firm is on the other side, as they have been in a number of my cases, all they have to do is ask the judge to punish me and my client if that's a frivolous lawsuit, and he can institute fines, what we call sanctions. He can penalize us, he can make us pay the other lawyers' fees. That's already existing law. We don't need a new law to do that. We've already got it on the books. You don't need to keep passing laws one after another when you've already got it on the books. Frivolous lawsuits is not the problem, and the legitimate lawsuits are not hurting the economy in this country. Healthcare costs, legitimate lawsuits take up about 1 to 2% of the overall national healthcare cost. It's not a big problem. It's not a contributor to the major healthcare problem or cost in this country.
Let me direct a question to you, Mr. Abel. Forum shopping, F-O-R-U-M, shopping, is, for our viewers, the selection of a jurisdiction where the suit shall be filed. And a limitation on forum shopping by plaintiffs is being proposed in this legislation, whether it be within the state of Oklahoma or be from one state to another, such as between Texas and Oklahoma. Why shouldn't forum shopping be stopped and just let the case be brought where the wrong was committed or the cause of action arose? 2 minutes.
Well, the term forum shopping makes it sound like it's something that's evil or bad. The forum is where you bring the lawsuit when you file it. Now, generally speaking, you can bring the lawsuit either in the area where the accident occurred, such as an automobile accident, or where you can obtain service upon the defendant. For example, you need to have some flexibility in where you can bring the lawsuit, because you can't always get all of the parties in the same jurisdiction. If you were traveling from, say, like New Mexico, and you bought a car in New Mexico, or you had your car serviced and there was some defective work on it, you had an automobile accident in Oklahoma, that's where the legislation would propose you have to bring the case. But you can't get service on those people in New Mexico. So you're going to have multiple lawsuits. The court has the power, when you file a lawsuit, to transfer that case from one county to another, or in federal court from one state to another, to make sure that everybody is treated fairly and equally. Also, you may have an area such as in Oklahoma, if you needed to bring a case in New Mexico, but all of the doctors who treated you were in Oklahoma. Some of the convenience for some of those witnesses who are going to appear in court and going to be subpoenaed to come to court has to be taken into consideration. But what I'm saying to you is that the system is flexible, but the judge is sitting there to make sure that everybody is treated fairly. And if a defendant feels like that the forum where the case is brought is unfair, all he has to do is file a motion and ask the court to change the area where that case is going to be tried.
30 seconds.
And the court can take that into consideration and do whatever is fair. If that's not fair, then there's the appeal. I mean, a party who feels like he's not getting a fair ruling from the court can take it up to a higher court and get that reversed if he is right in his contention that the venue is not fair.
Senator, 1 minute response.
Well, Mr. Abel is correct. The system is flexible, and from my point of view, it's too flexible. I'll give you one example that's ongoing here in Oklahoma right now. There's an automobile manufacturer that is being sued in Oklahoma, and Mr. Abel's correct. Sometimes there are reasons based upon the parties or the circumstances where it might make sense to have the trial in a certain locale. But what's involved in this situation is a manufacturer who the only contact that this case has with Oklahoma is that a rental company had the car at one period of time for a short period of time, but the accident occurred in Maine. It involves injuries from a group of immigrant workers who are non-residents, and there's absolutely no contact with the state of Oklahoma, but and an action was brought to remove the forum, but it was denied. That's too much flexibility. It needs to have, the level of minimal contacts needs to be raised.
Thank you, and thanks to both of you. This concludes this particular segment of our special 1-hour edition of The Verdict. Stay with us, because when we come back, I'm going to step back and let each participant ask the other a question. That should be interesting. You're watching The Verdict. We'll be back in just a second. This is You're back on The Verdict, the special 1-hour edition debating tort reform. Now, for this particular segment, we're going to allow each of our participants to ask the other a question. We're going to start with Mr. Abel. You have 30 seconds to form your question to Mr. Coffey.
Senator Coffey, I'm told by all of the journals that I read and the people that I talk to that one of the most attractive things about the state of Oklahoma for businesses looking to come in here are its people. They're of high integrity, they are hardworking, they're good, honest people trying to do the right thing. Are you telling me, and are you telling the people of Oklahoma, that we need to put a uniform cap of $300,000 on all of these cases for non-economic damages, and that the jurors in Oklahoma who sit on those cases, the same jurors who decide whether a person lives or dies in a criminal case or whether he goes to prison, are not qualified to determine on a case-by-case basis the amount of damages that should be awarded to an injured person?
2 minutes, Senator.
Well, Ed, I appreciate your question. I think Oklahomans are the greatest people on earth. My wife is a fourth generation Oklahoma. My kids have been born here, they're going to be raised here, and I hope that they grow up and raise their children here. So I'm a huge fan of our citizens, and I think that they're more than capable. But I think the non-economic damage cap needs to be controlled because it doesn't really have anything to do with trusting juries. It has to do with cases that are filed and the punitive damages that are used as a leverage to get settlements for cases that shouldn't otherwise be filed because they never get to the juries. It doesn't have anything to do with trusting juries. It has to do with the method and the system that we follow today as far as what's filed.
Thank you. Now it's time for you to ask Mr. Abel a question.
Mr. Abel, could you tell me, there's 14, 15 points in the governor's proposal. What parts of the governor's tort reform proposal could you support?
I can support anything if it needs to be passed. I can support anything to do away with frivolous lawsuits. Nobody wants frivolous lawsuits. My only point is that we already have statutes on the book, and I don't know how you're going to improve those because the authority is there, and once you give authority to the judge to do away with the frivolous lawsuits, you can't give him any more authority when you've already given it all to him. I am for anything that brings about fair verdicts. But under the system that we have now, if a jury, who I think Senator Coffey has just agreed is qualified enough to be able to make a judgment on a case-by-case basis, but if a jury happens to make a mistake, if you happen to get an outlandish verdict, our trial court has the authority already to do away with that verdict, to grant what's called a remediature or to set the verdict aside. And we have an appeal system, which if the trial court doesn't do his job, the appellate court will. So I guess my answer is I really don't find a lot in the proposals that are out there in front of the state legislature now that is needed because we already have safeguards in place. And I don't think this whole debate is really about, if you look beyond the surface, my grandfather used to have a saying, and that was, if you follow the dollar, you'll find the real source of what's going on. And I think this is a proposal by insurance companies to put a cap on legitimate lawsuits because they don't want to see those lawsuits in court. Every case in court gets settled either out of court or it gets settled by a jury.
30 seconds.
Now, Senator Coffey has said, well, these cases don't go to court. Any case can go to court. If a defendant feels like he's being sued by a frivolous lawsuit, let him ask the court to enter sanctions against the plaintiff. If he feels like it's a case that ought to be defended, let him go to court and let that Oklahoma jury decide the case. We do not need an automatic cap that is across the board in every case.
Thank you, and we're rushing to another break so that we can get back and hear the closing statements of each proponent on why we should or should not have tort reform. You're watching The Verdict with Ed Abel and Glenn Coffey. We'll be back in just a second. Thanks.
So how long are we?
Welcome back to our final segment in our special 1-hour edition of The Verdict on tort reform. And now we're going to hear from our two participants in their final remarks to you on why you should or should not support the tort reform. And we'll start with Senator Coffey. You've got 3.5 minutes.
Thanks, Ken. Well, why are we sitting here today discussing lawsuit reform in Oklahoma? The reason we're having this discussion is because a lot of people think there's an issue, that there's a problem. Perhaps what most recently started this debate was an editorial in the nation's newspaper, the Wall Street Journal, that put a spotlight on how welcome and how open Oklahoma is for businesses. It was in response to a letter from an attorney in this state trying to solicit business from Texas attorneys because the reforms that were put in place in that state obviously are going to hurt the ability to bring lawsuits that might bring about large verdicts. And he invited them to Oklahoma to become the state for that forum. Mississippi had that experience, and it was devastating for the business community. I don't want Oklahoma to become the next one on that list. We need to address reasonable reforms like joint and several liability, like loser pays, like reasonable limits on non-economic punitive damages. I think these are reasonable steps that are working in our neighbor to the south. We need to look at these reforms. We need to pass these reforms because all of us want to grow this state. This isn't about trying to put one group of individuals out of business. There still is a need, and it's important for us to have a fair, affordable, and accessible legal system, and I support that. But it's also important, just as our founding fathers proposed, to have a thriving, free enterprise system that promotes job growth, that promotes the entrepreneurial spirit. Today, about a third of our medical costs are tied up in defensive medicine practices, worrying about what tests they should offer or what should be prescribed that might come up in a deposition later, rather than treating the health issue. We have manufacturers and service business who worry about defensive business practices rather than trying to provide the best product for the lowest price to get your business. Businesses have to provide a good product that at the end of the day satisfies customer service. If you don't have a good product, you're going to go away. Microsoft didn't become the large computer company that they are today by having a faulty operating system. They pushed for quality and they delivered. That's what this argument's about. It's not about trying to pick on a specific industry. We want to make Oklahoma grow. We want to make Oklahoma great. We need to welcome businesses to the state. We need to keep our medical professionals here to have a healthy workforce, and that's what this debate is about.
Thank you, Senator Coffey. Mr. Abel, your final remarks.
I have all of the due respect for Senator Coffey. He's a very fine individual, and he's a friend of mine, but he's just wrong. I hope you, listening to this program, will not support tort reform because somebody says business is in trouble. Senator Coffey cannot point to one business that's failed to come to Oklahoma or that has left Oklahoma because of our legal system. Senator Coffey cannot point to one doctor who has quit practice or who has left the state of Oklahoma. And it's almost like if you say it long enough, yes, everybody's in favor of a good economy, so we must need something. Our economy is doing great. And in fact, there was an article published by the president of the Oklahoma Chamber of Commerce recently who gave us a list of 10 things that businesses look at in coming into Oklahoma. And our legal system was not one of them, not one of them. They look at the schools, they look at the tax structure, like in Texas they don't have income tax, personal income tax. They look at tax breaks that companies get. They look at where the airports are located because they have travel in their businesses. They didn't list one time anything about the need for tort reform before those businesses would come to Oklahoma. Make your decision based upon the facts. Now, for example, we've talked about why doctors' insurance rates are up. It's important to know that of the national health care cost, the legal system, it's attributed to less than 2% of the cost of our national health care system to the fact that lawsuits are brought against doctors. I hope, for goodness sake, that doctors are more careful because they might get sued if they're negligent. I hope, for goodness sake, manufacturers make their products safer, as they did with children's nightgowns, little girls' nightgowns. That did have an effect, that punitive damage award. I hope that has that effect because we need it in Oklahoma. What we're really talking about, well, for example, though, on the doctors' insurance rates, PLICO, who insures all of the MD doctors in Oklahoma, reinsures every one of their cases that they think they might have a liability of more than $400,000 with AIG, the nation's largest reinsurance company on medical malpractice. AIG is making millions of dollars because they've raised their rates. They make so much money that they pay their president $250,000 a week. That's how much money they're making, and that's why PLICO's rates have gone up, not because of lawsuits. What we're really talking about here, and Senator Coffey said it, I don't know if he intended it or not, but in Texas they've cut out the big lawsuits. Now, you know, the lawyer that wrote that letter, that's one lawyer, and he was puffing, trying to get business. All lawyers don't agree with that, and that is not a true statement of what goes on in Oklahoma. In Oklahoma, we trust the decision of what should be done in an individual case to the citizens of Oklahoma, and it takes 9 of 12 sitting on a jury supervised by a court. What they're really proposing to do, what the insurance company is proposing to do, is to take away your right to go to court. If you're limited, for example, if you have a $300,000 limit on pain and suffering, and you get somebody, a child who's not making a salary, and he's burned over 75% of his birthday on his, 75% of his body on his 21st birthday, he's going to be limited to $300,000, even though he's permanently scarred. To put that case on, it'll cost over $300,000 to try the case. There won't be a lawyer be able to handle that if that kind of cap is passed.
Thank you both. We have been visiting today, and you've been hearing from Senator Glenn Coffey and Ed Abel, trial lawyers. We're really pleased you guys could come. You've given us a lot of good information. And now, folks, it's your turn. This show's called The Verdict. What will be your verdict? Please go to our website, www.theverdict.tv, not .com, but .tv, and there you can go click on poll, and you will see a question, and you will have a chance to answer. Do you favor the passage into law of the tort reform as described in this show? You can click yes, you can click no, or you can click in favor of a modified tort reform, and if you do that, we ask you please explain with a comment. Once again, thanks to our guests. We are really pleased you joined us on this special hour-long show of The Verdict, and we'll see you next week.